Imagine you're a small guitar builder. You design your own pickups, your own electronics, your own finish, and your own brand. You never put the word Fender on the headstock. You never copy their logo. You never tell customers your guitar is a Fender. And then one morning you receive a cease and desist letter. Not because of your logo, not because of your brand, but because of the shape of your guitar. That may sound unbelievable, but this is exactly the debate taking place today. The dispute centers around one of the most recognizable instruments ever built, the Fender Stratocaster. Introduced in 1954, the Stratocaster became one of the most influential electric guitars in history. Its double cutaway body, its contours, its balance, its ergonomics. Millions of musicians chose it because they liked how it felt. Over the following decades, countless manufacturers built what players simply call S-style guitars. Not because they wanted to fool customers, but because customers wanted instruments with the same ergonomics and playing experience. For decades, this became normal throughout the industry. Then everything changed. Following a court decision in Germany, Fender began sending cease and desist letters concerning the Stratocaster body shape. Supporters argue, if Fender created the design, why shouldn't Fender own it? At first glance, that seems perfectly reasonable. But economics begins where institution ends. Before asking what the law currently says, we should ask a much more fundamental question. What is a property? Praxeology begins with human action. Human beings act because resources are scarce. If two people want to use the same piece of land, both cannot use it in incompatible ways at the same time. The same is true for a house, a guitar, or a loaf of bread. Property exists to avoid conflict over scarce resources. Without clear ownership, peaceful cooperation becomes impossible. That is why property rights emerge. Now consider the shape of a guitar. If I build an S-style guitar, have I taken one of Fender's guitars? No. Does Fender lose possession of its factories? No. Do existing Fender guitars disappear? No. The physical property remains entirely untouched. What is being claimed is not ownership of a guitar, but ownership of a pattern. That distinction is crucial. Property traditionally resolves conflicts over scarce things. A body shape, however, is not consumed when someone else uses it. Millions of builders can independently produce similar shapes without preventing Fender from building another Stratocaster tomorrow. The conflict is therefore fundamentally different from ordinary property disputes. Now, consider the economic consequences. Suppose one company receives the exclusive legal right to prevent others from using a body shape that has become an industry standard. What happens? Competition declines. Market entry becomes more expensive. Consumers have fewer choices. Small builders face greater legal uncertainty. And established firms gain advantages that arise not from better products, but from legal exclusivity. Notice what happened. Nothing about the guitars themselves changed. Only the legal rules changed. This is where many people confuse two very different questions. The first, what does current law allow? And the other is, what kind of legal order best supports peaceful cooperation and voluntary exchange? Those are not the same question. A court may recognize a legal claim. That does not automatically mean the rule produces better economic outcomes. Praxeology asks us to examine the incentives those rules create. In a legal order centered on protecting tangible property, contracts and fraud, the central questions would be different. Did someone steal a guitar? Did someone deceive customers into believing the product was made by Fender? Did someone violate an agreement? If the answer is no, then what scarce property has actually been taken? That question goes to the heart of the debate. This is why the discussion extends far beyond guitars. It is really a question about the limits of property itself. Can ownership extend from scarce physical objects to patents that countless people can reproduce independently? Or does such an extension gradually transform competition into legal privilege? This is not merely a legal question, it is an economic one. And from a praxeological perspective, every answer begins with the same simple principle. Property exists to resolve conflicts over scarce resources. The entire debate turns on whether the shape of a guitar belongs in the category.